How is it going, everybody? This is Stephen A. Williams, president and founder of the creditrepairshop.com, and in this video we're going to talk about how to respond to a debt collector's court summons. Yes, there are a lot of people that are getting sued by debt collectors, and this is just an image that I got off of Google because I don't want any of my clients to think that I'm using their information, or I don't want to reveal anything from somebody. So I just took this one off of Google, and it's a good example. It doesn't have one section though that I wish it would have had. But remember in the video that I made yesterday, if you didn't watch it, please go and watch yesterday's video where I talked about with debt collectors and how every state is different and how you have to respond more in some states and less in other states, and how when a debt collector sues in certain states, there's more information that is required, and in some states, mostly the southern states, there's less information that is required for a debt collector to be able to sue you in court. So this is one that I found online. This is Los Angeles court, and you could see here that it would have the debt collector, and it says assignee of Citibank. And I'm going to tell you how to deal with that, because that right there becomes sort of a problem for them, sometimes depending on what judge they're in front of. And then right here they have the amount of the demand. They would have the individual's name, and they would also state that it could be alias or misspellings. They try to, they try to put in as much as they can, so just in case if there was something that would be considered a technical mistake, that it won't get the case thrown out. It would also have the case number right here, and you're going to need all of this information to respond. You would need this. You're going to need all of this. Obviously, your name. You're going to need the case number, and then you would go into answering. Now, in my other videos, I've always said that you have to answer the allegations, and people would say, well, what allegations? I just see these numbers on here, it just says 1, 2, 3. These are the allegations, and you could see how they're stating on here. Like, let's just go off of number 1. Plaintiff is and at all times herein mentioned Calvary SPV1 LLC as assignee of Citibank NA and successor in interest to original creditor Citibank NA. So you would have to respond to that. Don't worry, I'm going to give you access to something where you'll be able to see how to respond to it. But you have to respond to each line on this. Some of it might seem redundant. They do this stuff on purpose because, number one, they want you not to respond. And not every court is going to say that you have to respond to every line, because they don't expect you to be an attorney doing this, but you do have to respond. And so for things like this, you would just say, hey, not enough information, or you would want them to prove this information here that they're saying about the assignee. And I'm going to go into that in a minute. I'm going to show you how you can respond to really a lot of this in just one line. So they got here that they're just notifying the court that they're a debt buyer, that they're the sole owner. That just because they state that does not mean that that's the end all say all. You want to get a chain of custody of how they got this. Was it purchased from another portfolio company and then passed over to them? And then they got here just notifying that it was a charge off. Says here, charge off creditor at the time. Well, the charge-off creditor at the time of the charge-off is Citibank NA. They're just notifying them of who it was, an account associated, and they got all of this on here. This is a problem because you have a right to know the full account number. They can't just come into court and say that this is the account number XXXXX and then have the last 4. You have a right to have them reveal that whole account. But I'm going to go into how we even tackle all of this in one line of your response. And then it says here that the defendant are individuals who reside at, and then it would have on another line here, it would have that person's address. And you would just say, yes, I reside at that address if that is your address. If not, that you just say that that's not your address. So now let's just go here and just have our imaginary line here, number 6, because usually number 6 is going to talk about this right here. They're going to go into a lot of detail about how they got that number. They're going to probably say that they have an affidavit. They're going to say that they, had a bank statement. Or the last statement or a couple of statements. They're going to have a lot of information that was given to them from the original creditor. But let me tell you the things that they don't have from the original creditor. So when you're responding to them, when you see the line that talks specifically about the debt, you're going to need to ask them these questions. And what made me want to even make this video again, because I have had other videos that answered this, is that a video came across my YouTube channel, or when I was on YouTube, and it had a an attorney that wrote the responses also for individuals for debt collection lawsuits. And he specifically stated that they don't even go to court for people on this. And the reason why is because it's kind of hit and miss, and attorneys don't want to take people's money. If they're going to go into court, they're going to end up charging, maybe even $1,500 to $2,000 in the debt. So they could end up paying that and having this whole amount having to be paid. So they don't want to put themselves in that position. And so what I've always said is that put yourself in the position to win. Go in there and fight for yourself. Get everything put together the right way, and then you'll have at least have a fighting chance of winning. And the crazy thing about it too is when he was given his information about what to watch out for, the 7 mistakes, man, the mistakes really bogs down to just not answering the summons. It was crazy that he was given that information. So I had to make a video to help people just in case they get confused by watching one of those videos. So you answer this stuff here to the best of your ability, but I'm going to show you how to answer it really all in one, and then how to answer all of those within the one. So number one, when they talk about the amount of the debt, the way that we attack it, number one, is we would want Calvary to prove how, number one, prove how they got it, how they got the debt. They might have an affidavit in there showing that they purchased the debt or that they were assigned the debt from someone else. Whatever they have, you're going to have to do some work on getting all of this in order. But you want to see how they got the debt. And then using that information, you're going to attack them this way. You're going to say, okay, I want to see how they got the debt, and I want to see how they got to this amount for it. And they're going to try to say that they got it, they know that amount from your statements. What you're going to do is you're going to flip that around on them, and you're going to say, I want them to show me specifically all of the charges, because this is a credit card, all of the charges that equal the $6,000 for this one here, the $6,006. You want to get every one of them, and you want to have your signed signature authorizing the charges. So you want to have them show you how that amount came about, and the signatures authorizing all of the charges. They have to get that. If you were to call, just say that if the account was still with Citibank, they could give you a rolling log of all of your charges with the signature, either digital, or if you were at a location, they would be able to give you that information. The other thing that you want Calvary to prove is that how did they get access to your personal info. So they're going to obviously say that they got it from Citibank, but you want to get a document from Citibank giving them the approval to share your private information with a third party without your permission. You want to get that permission. We hear that all the time, everywhere, where they state you got to sign these privacy acts or, privacy releases. Well, you want to see the privacy release that you gave to Citibank to share it with Calvary. Calvary must provide you that information. They can't just, contact you out of the blue. You want that information. Then also, what we had talked about right here, because they're going to try to send you statements, and on those statements, it's going to have XXX and it's going to be blocked out with the last 4. You want them to disclose the complete account number.
Returning visitor.
You want them to disclose the complete account number, because you maybe had a few different accounts with them and they match the 4. You don't say that directly, but you can just say that you want to review the complete account number to make sure that this was your account. You have a right to do that. That's you getting all of the evidence to make a determination if this whole account is yours. All right, check this out. This is what I did. This is special. When I had paused the video because I was thinking to myself, there was one that I did for a California client, and I was like, I can show you what I did for that specific client so you can see what I'm talking about, and it would help you on being able to respond to debt collectors. And best part about it, I knew I wrote this one where it wouldn't reveal anything about that individual. So you can see here where we're responding to right here. So this one happened to be with LVNV funding, and you can see here where I talked about authorizing them to handle personal information, including disclosure of social security number, address, phone number, and other personal information that has been provided, sold, or assigned to them. Remember, they had talked about having it assigned. I requested LVNV funding disclose complete alleged account and true accounting statements showing how the alleged account balance of $14,000 was accumulated with specific individual approved charges, the amount claimed with my signature approving the alleged charges. And then this is what we would put when there's something that you don't know the full answer on, or it's just something that, you're just going to respond to them saying not enough information provided. And in here, not enough information provided, plaintiff did not provide complete account number. This would have been like what the one I just showed you where they had a partial account number. This one here, plaintiff had not provided information showing the sale, transfer, assignment of alleged debt, including all accounting records, documents, and my signatures, allowing them to share. This is just like a repeat. And the reason why we added this line in there is because reading through the affidavit that they gave, it wasn't directly sold to LVNB. It actually went to Sherman first. Well, it went to Sherman second, Sherman third. This was the third, this was the second owner, and this was the first. So we stated this, and we said we want to incorporate our answers with this one. So we want all of them to tell us how, or tell her how this information was, how they shared that information, and each company, because LVNV could try to say, well, we got it from them, that balance and that account number, that partial account number. So we want all three of them to say how they got to this, and each one is going to have to send a response to to LVNV, because LVNV is the one that's actually doing the suit. And then this was the answer to, do they reside in that county? Because they have to sue you in the county that you live in. Name and address is correct. And then this was just responding to, I'm pretty sure these here, whenever you see how I answered these, it was just like a repeat where they were just basically restating the information about the debt. And we just, rather than just repeating it ourselves, you could say you incorporate your answers in number 1 through 4, which was those 4 that were above. And then here I added, in addition, no original contract from Cross River Bank, which was the original creditor, was including, showing signatures, ledge account number. None of that stuff was provided with the documentation that they provided. And then we go down, and you can see how all of these are on here. Some of them in most states will be like 1 to 10, but in California, you're going to get where it's going to have a lot of these lines. They make them really prove, or they make them go through a lot to file that lawsuit in California. These were just repetitive again. I just put the answer that we had. Again, repetitive, and I incorporated 1 through 4 and 9. And let's see what 9 was about the bank. They had probably stated something about the account with that bank that they purchased the debt from. And the crazy thing about this one was when we broke this down and we saw that these 3 had it first, it kind of made it easy. Well, not easy, but it kind of started breaking down what they had in their suit, because they had first stated that they got it when they even showed with the evidence that they provided that they did not directly buy the debt. They state that they followed the California laws and that it was not past the 4 years of statute of limitation, but we thought that it could be past the 4-year statute of limitations based on the information that they provided and based on what we saw on the credit reports. It was not fully clear on the credit reports when the actual charge-off date was. For some reason, when we looked on there, it was just not clear. It could have been an issue with the reporting by the original creditor. I don't know, but we decided to state this in here and let them work that out, because it potentially could be past the 4-year statute of limitations for state of California. And then again, we repeat it. So you can see here, it takes some work to do this, but we repeat it instead of just being redundant with our answers. And then you can see those there. On their exhibits that they gave, does not show the debt in the name of LVNV Funding Sherman. Look at that. Nor Cross River Bank. No documentation presented connected me to your alleged account. In their affidavit, which is crazy, it did not have the individual's information in there, and it did not have a document showing that any of these companies, that what they had provided, what they had presented, it did not show a connection with this, the Cross River Bank, with even getting purchased by these companies here. It didn't show that, so we wanted to put that in there. And then these were they were being redundant again, so we just had the answers. And then they went into their second cause, which is really just being redundant again. And then I had stated that it could potentially be past 4-year statute of limitations, and we repeat 1 through 22. We asked that the court, when this individual was going in to represent themselves, but we stated that they would like to have this dismissed due to the plaintiff not providing complete documentation to prove the alleged debt. And then we got the affirmative defense here. Not provided documentation showing the contract between myself, LBNB Funding, Sherman, and Sherman Originator and Resurgence. Not providing any documentation showing allowed them access to my personal information, any transfer of that data, any of that. Remember, we living in this privacy world. Did not show complete auditing of the account, alleged amount $14,000. Did not provide any documentation showing the purchase of alleged account of $14,000 with complete account number, with complete name and account number. With this one, one of the sneaky things that they've been trying to do, and I think it's because of the responses that we've been doing for people, is that they'll have a document, but the document will show the debt collector. So they'll have a document with the debt collector name on there, but not with the original creditor. But with that document, what they're trying to do is give the impression that that document came from the original creditor, but it really did not come from the original creditor. It does not show any information. All it's saying is that they'll put the person's name and the account number on there, and when they provide that to the court, it has a misperception that it was given to them from the original creditor, when it was just a document that they produced and they had one of their own staff members sign as the witness, which is crazy. So we started responding to that letter there when they put that in there. All right, so I hope that this helped you. These debt collectors are starting to get more aggressive in court, and you do have to respond, or you're going to end up getting a default judgment against you, or at least give yourself a fighting chance. And if you need help with this, we do have a service where we provide the responses. You do have to go to court. You have to get the information to the court so you can at least have a fighting chance. But these have been working so far, and we've had a good streak of either getting them where the client was able to get them dismissed, or they would just ask for more time to get the documentation, which will eventually end up being a dismissal. All right, so the link is below this video. If you need help with your credit, please visit us at thecreditrepairshop.com. Watch the video, What Makes Us Different. I show you step by step how we repair credit. And then if you need your credit reports and scores, please go to the website your3scores.com to grab your reports, complete reports and scores. And I have my debt collection letter, so you can stop debt collectors before it even get to this point. And you can get my 3-pack of letters, statute of limitations, debt validation, and cease and desist collection activities letter. All right, thank you for your time. This is Stephen A. Williams, president and founder of thecreditrepairshop.com.